Doesn't matter wherever you want to sit. Okay, I think we'll get started. Prior to the break, our panel were charged with the responsibility of the nuts and bolts and how to avoid LPIC claims. This panel was put together with the idea that the road ahead appears to be still long and tortuous, and the law is silent on certain areas, and our legal personhood is still to be worked out over the course of the next few, hopefully, not too many years. So our distinguished panel is here to talk about those areas where the law has not been speaking on behalf of all the members of our community, and to look across the borders to see where we can learn from outside of Canadian jurisprudence. So I'll start by introducing our panel. To my furthest left, and I think appropriately there, is Marguerite Russell, who is a very senior barrister and member of Lincoln's Inn in London. I met Marguerite when she was doing her LLM at Queen's University, and she subsequently, in my view, foolishly decided to put herself through bar ads here in Ontario. I'm a member of the bar in Ontario. She was a founding member of 2 Garden Court chambers, which is recognized as one of the leading common law sets, which Marguerite explained to a dumb Canadian lawyer like me is a set of chambers very similar to barristers, very similar to law firms here in Ontario. As a senior member of the UK bar, she has specialized in civil liberties and criminal cases, including cases involving lesbian and gay rights. She has been active with the bar Lesbian and Gay Group, the Lawyers Lesbian and Gay Group, and Stonewall. In Canada, she has taught advocacy courses at Queen's University, represented Bonnie Robichaud in her damages hearing on the sexual harassment claim against her employer, the federal government, and has acted as an international observer for the Fédération Internationale Droits des Hommes during the Oka crisis. Next to Marguerite is Professor Mark Wojcik. Mark is a teacher of sexual orientation law and international human rights law at the John Marshall Law School in Chicago. He was the founder of the Chicago Bar Association's Committee on the Legal Rights of Lesbians and Gay Men, which I believe, Mark, was the first of its kind in Chicago?
In Chicago,
In
yes.
Chicago. He was also the openly gay chair of the Chicago Bar Association's Committee on Military Law and Veterans Affairs.
They didn't ask and I didn't tell.
He now serves on the board of managers of the Chicago Bar Association. He is a regional delegate for the National Lesbian and Gay Law Association, and in August will become the chair of the American Bar Association's International Human Rights Committee. Seated next to Professor Wojcik is Laverne Monette. Laverne is a two-spirited Ojibwe woman, originally from Winnipeg, Manitoba. She is a graduate of the University of Toronto Law School and was called to the bar in 1990. She's currently works as a provincial coordinator of the Ontario Aboriginal HIV/AIDS strategy in Toronto. The strategy has 7.5 workers located throughout Ontario who provide health promotion and HIV/AIDS education to urban Aboriginal communities and support and counseling services to Aboriginal people living with HIV and AIDS. Laverne is also on the board of directors of Two Spirited People of the First Nations, an Aboriginal AIDS service organization in Toronto, and the Canadian Aboriginal AIDS Network, a national lobbying and advocacy group. And seated right next to me is John Fisher, who everyone I'm sure knows is executive director of AGAL, a national lesbian, gay, and bisexual equality rights organization. John holds a Master's of Law degree from Queen's University, where he wrote his thesis on lesbian and gay rights under international law. He also teaches a course at the University of Ottawa on lesbian and gay legal issues, and a course at the University of Carleton on lesbian and gay issues under the Canadian Charter of Rights. Mr. Fisher has been called by the Canadian Human Rights Commission to testify as a witness on same-sex equality rights, and has co-presented on lesbian and gay issues at education workshops organized by the National Judicial Institute for Ontario Court Judges. Mr. Fisher has testified before numerous parliamentary and Senate committees. He was Grand Marshal of the Toronto Pride Parade in 1998 and has represented EGAL at a number of international human rights conferences, including speaking before the Plenary Assembly of the United Nations World Conference on Human Rights in Vienna. I should add as well, in terms of members of our community not included in the law, we had invited a transgendered lawyer from the United States who unfortunately could not make it here today. And a couple of our speakers will sort of try to touch on those areas, but that's certainly worthy of a conference on its own, and we certainly did not overlook it today. And so with that, I'd ask John if you'll start. Each of the panels will speak for about 10 minutes, and then we hope to have a question and answer to talk about the bigger pictures of legal personhood.
Sure. Well, hi, and I was very interested by the title of today's conference, Are We Persons Yet? Being naturally an optimist at heart, I would reply with a resounding maybe. I think I've been astonished by the extent to which we've seen progress in just a very short space of time. Things have really begun to move, and it feels like we are standing at a threshold point. But there is a lot that still lies ahead of us, of course. At the classes that I teach to students at the universities of Ottawa and Carleton, we usually start with a look at the history of lesbian, gay, bisexual rights in North America and elsewhere. And the way we do that is to put up this big timeline on the wall and get people to just mark off significant points in the development of the movement. And partly it's a reflection, of course, just that we're more familiar with recent events than with historical events. But we usually find a few people who are able to sketch off in the early decades where Jim Egan began working in Canada as a pioneer activist. Our knowledge of the 19th century and before is always a bit sketchy, and we need to fill in some gaps there. Of course, people are familiar with decriminalization in the 60s. Through the 70s, we have things like the opening up of the Immigration Act, so that homosexualism, as it was called, is no longer a ground on which people can be denied entry into Canada. Quebec decriminalized in the late, sorry, not decriminalized, but added sexual orientation to its human rights legislation in the late 70s as well. And then mid-80s, we have Ontario following suit with sexual orientation in its human rights code in 1986. But through those years, there's many low points, and the gains are separated by periods of years and decades. And then we hit the early 90s, and things really start to move. We have a succession of provinces which begin to add sexual orientation to their human rights legislation. We have, through cases like that of Michelle Douglas, the removal of the ban on gays and lesbians in the armed forces. We have a succession of cases in which legislation is challenged, often successfully. By the time we're at the mid-90s, we have the Canadian Human Rights Act being amended to include sexual orientation, the development of hate crimes legislation to include sexual orientation, the remaining provinces bringing their legislation into line so that we have almost universal protection from discrimination for gays, lesbians, and bisexuals in this country now, although transgender people continue to be explicitly excluded, at least, or not covered under the explicit terms of existing legislation. And then, really, just in the course of the last year, and even in the course of the last month, an extraordinary array of steps have been taking place and are building up to, I think, some very exciting steps over the course of the next year. The MNH case, of course, has been a tremendous breakthrough, and full credit to Martha for her drive in seeing that one all the way through the distance. At the time that we were gathered at the Supreme Court that day on May 20th, our little EGAL team, we had convinced ourselves that we were going to lose that case. And we were all very pleasantly surprised to see not just a victory, but an extremely solid victory, with 8 Supreme Court judges finding in our favor that was far more solid than I had anticipated. And I think it's a reflection of where the Supreme Court is at, too, that there's some very sensitive writing in that judgment. There's a good analysis of the impact of discrimination upon gays and lesbians and those in same-sex relationships. There's a good recognition of the fact that our relationships are as diverse as heterosexual relationships, and that we're not required to fit ourselves into any particular family mold in order to suffer the impact of discrimination and need to be equally protected under the Charter of Rights. Within 5 days of that decision, the government passed, or the House of Commons passed, the the first ever piece of legislation to recognize same-sex relationships equally, and that was Bill C-78, the Public Service Superannuation Amendments, which extended same-sex survivor benefits under the Superannuation Act to gays and lesbians. Now, that piece of legislation was opposed by all of the opposition parties on the basis that it additionally would have enabled the government to claim a $30 billion surplus under the pension fund, and none of the opposition parties were particularly impressed by that. But the government nonetheless had the numbers to see it through the House of Commons. In addition, and one thing that got very little public coverage, considering that the magnitude of what was accomplished, Quebec became the first province in Canada to pass omnibus legislation amending all its laws to put same-sex couples on an equal footing with unmarried heterosexual couples. Now, this is the Quebec equivalent of what Bill 167 was in Ontario, and of course that failed in Ontario. As a result, some of the Quebec legislation, some 40 or 39 laws and regulations have been amended to include an equal definition of spouse or family or whatever the appropriate term is in accordance with the legislation. And I have to say it was extraordinary to me at the ease with which that went through and the minimal attention it got across the country. I mean, as a kind of aside, it speaks to the two solitudes of Canada, that I'm sure if that was Ontario and the Mike Harris government putting through that legislation, it would have been in the news over a course of many months and would have got national play. The other thing that's extraordinary about it is that the Quebec National Assembly passed the legislation unanimously, so that the government, the opposition parties, everybody supported it. There wasn't a single vote against. And the only concerns that the Liberal opposition had was that it didn't go far enough in their view. But they nonetheless supported it. And it's difficult to think of another jurisdiction in the country, and certainly not at the federal level, where we'd see unanimous support for a same-sex bill. And now, the qualification on that is that in Quebec there is still quite strong differential treatment between married heterosexuals and unmarried heterosexuals. So putting us in the same position as unmarried heterosexuals still does not encompass many rights that would be encompassed in other jurisdictions in the country where we put on an equal footing. For example, the spousal support rights and obligations that were an issue in M&H are not extended to unmarried heterosexuals in Quebec, so the legislation doesn't go as far as BC has gone, and doesn't go as far as the Ontario government will hopefully be obliged to go in 6 months' time when they follow through on the M&H case. And similarly with inheritance rights, BC is now looking at inheritance rights, but that's not encompassed within the Quebec legislation. So it is a time of great change, and as a result of a combination of factors, the Prime Minister is, we know, looking at omnibus federal legislation, possibly in the fall, to change all the federal laws, of which there are some 58, to provide equality for those in same-sex relationships. The Prime Minister has not always been our greatest friend on these issues, and has tended to waffle and hum and ha significantly when presented with them. His most recent pronouncement on the issue has been in January, when he said that he wasn't sure whether legislation was needed, and it wasn't on the agenda at this time. But he is reported to have become frustrated with the idea of having to advance equality and change the definition of spouse in 58 different pieces of legislation, one at a time, and have to face the difficulty of convincing his caucus 58 times over, rather than doing it all in one fell swoop. So it's a realistic possibility that will happen in the fall. In terms of why it's only a maybe on are we persons yet, I think it's clear that there's a lot of work ahead of us. There are still dozens, hundreds of laws across the country that continue to exclude us. Relationships is only one aspect of the struggle for equality, although it tends to have been one of the more prominent ones. There are cases going to the Supreme Court on censorship, the Little Sisters case in BC, which looks at discriminatory practices of Canada Customs, where they often target lesbian and gay bookstores and and ban and sometimes destroy materials that are not destroyed when they're destined for heterosexual mainstream bookstores. There is a significant case taking place in BC dealing with education in schools and banning of books and materials that apparently promote the homosexual lifestyle. And there are a range of other issues taking place across the country. It's also interesting to me that the Supreme Court, when they had the chance, dealt very offhandedly with the Egan judgment in M&H, and within a single paragraph just said, essentially, that's a different case, and let's now turn to look at the case in M&H. And it's hard to see how M&H and Egan can be reconciled. The only obvious legal differences are differences that I hope would not make the difference in the result in future. The fact that we were looking at private obligations in M&H rather than access to public benefits in Egan. But the courts have said that that cost alone is not sufficient to justify a Section 1 defense, and so that can't be the whole of the story. The incrementalism argument was used in Egan, and none of the court seemed to endorse that in M&H. And the fact that it's individual versus government, again, I would hope would not be the basis for distinguishing the case. The truth of the matter, I think, is a lot more simple. The truth of the matter is just, I think, that the court has evolved in its knowledge and understanding of these issues and was ready to find in our favor in M&H where it wasn't ready to find in our favor in Egan. But that's not a legal reason, and no legal reasons were provided in M&H to reconcile those two judgments. So it's difficult to know why they didn't just bite the bullet and say times have changed since Egan, and how they're therefore going to reconcile those two cases in future. One of my concerns is they will continue to try and find means to justify why Egan was okay, but M&H was different, which inevitably would suggest that in other cases we risk losing if it's a case that looks like Egan or that involves access to similar kinds of benefits. So the next cases to come before the Supreme Court are going to continue to be crucial in determining what the future landscape looks like. The Reform Party, as many of you will have seen recently, passed a motion through the House of Commons which had the support of the government and MPs from all parties, affirming the continued exclusion of same-sex couples from the institution of marriage. And that was unfortunate. It was particularly unfortunate the government chose to throw its weight behind the Reform Party on that. In terms of the impact legally of that motion, it's not significant. Lesbians and gays were already excluded from the institution of marriage, so saying so twice doesn't really make it any more illegal. What's disturbing about it, though, is that the formulation of the motion was not only that marriage is one man, one woman to the exclusion of all others, but also that the government will take all the measures necessary to protect that definition. And it's clear, I think, that the Reform Party are laying the groundwork for the potential future use of the notwithstanding clause. And that's another area of concern. I think that putting that into the context of the struggle for equality generally, we've seen in recent years, with the gains made by the lesbian, gay, bisexual, and transgender communities, an increasing attack on the legitimacy of the Supreme Court to be making these kinds of decisions. We've seen an increasing pressure on governments to use the notwithstanding clause, which has previously been very politically unpopular, but is becoming certainly more talked about, and perhaps in environments are being created where it's not unthinkable. And the Reform Party have been strong advocates of that, and clearly we're seeking that with their motion. And it's my belief that should a court in future find in favor of same-sex marriage, this motion will be relied upon to try and persuade governments to invoke the notwithstanding clause. It's interesting also that I think it's largely as a result of the gains on the lesbian, gay, bisexual scene that we've seen the attacks on the court's credibility and authority to make these decisions. Clearly, they have the constitutional authority, but those who are opposing it are clearly basing their opposition on the fact that they don't like the outcomes. If the court were finding against us, they'd be celebrating the fact that the Supreme Court were making these decisions and ruling that we weren't family, but they just don't like the answers. but clearly it's having an impact on the court, because we've seen in cases like Vreen the court devoting pages to justifying why it has the authority to make these decisions at all. And I think probably the reason for the suspension of the remedy in M&H for 6 months is that the courts wanted to toss it back to government rather than make the decision itself. So I'll leave it there just to say that that's a brief overview of where we've come from, what we've seen just in a very short space of time, and also I think a reflection of the fact that there are many, many issues which still lie before us, and we're not there yet. There's the courts have left some questions open for future, and I think the whole struggle has certainly highlighted the tension between government and courts. And on my own experience, I don't have a lot of faith that governments will do the right thing because it's the right thing. If they do it at all, it will be because of a combination of very different circumstances. So what lies ahead very much remains to be seen.
Thank you, John. I hope, in fact, we have time during the question and answer period to talk about those issues as well. Laverne.
Thank you. I'm going to talk about something completely different, but I'm going to throw in a few of some of the legal issues and tell you why they're not, the issues that are addressed during this forum are not as significant for us, and there are good reasons for them. I need to talk about two-spirited people, which is our terminology, modern English terminology for gay, lesbian, bisexual, and transgendered people, and the many variations of that do exist. Traditionally, we know now from research that at least 68 tribes had more than 2 words of their own words in their own language describing people's gender and orientation. Some had up to 8. So, sexuality is very fluid. Historically in our communities, two-spirited people were honored, they were respected, they were treated extremely well. They were seen as a gift from the Creator. They were different, and difference in our communities was embraced because it added to the community. It didn't subtract. People weren't put in little boxes. And that was very important. We were mediators, healers, teachers. Oftentimes we would talk between men and women who were trying to talk to each other and couldn't. Because we had 2 spirits within us, a male and a female, we were seen as being able to see from both sides of it. And that went on quite happily for many thousands of years. And until the arrival of the Europeans, who came with fleeing certain kinds of religious persecution, political, economic, etc. Because the two-spirited people were honored and respected, they were also seen as leaders, and they were in leadership roles. So they were the first to be slaughtered. And they were slaughtered for a number of reasons. One, because they were powerful and they had influence, and the other because of what was perceived as their perversity and their sinfulness. We didn't have those concepts. Sexuality was seen as a gift. The use of your body and expression of it was seen as a gift from the Creator. It was a very healthy attitude. Not that everything in our lives was healthy and wonderful or paradise, certainly not. After the Europeans came, a lot of our traditions, particularly two-spirited traditions, went underground. We were Catholicized and Christianized, and I say it in those terms because the organized religions, and those were 2 that had the most influence on our people and were first contact with our people, brought their own concepts of what sexuality was about and what sexual orientation was. So we were severely Catholicized and Christianized. So what would happen is, because we're a very oral tradition, young people were taught about sex in their own language. We're very oral people. The Europeans did not speak the languages, so even talking about sex and what was healthy and what was going on would be done in native languages. As we went on and lost some of those languages, we also lost that teaching ability for our children and for each other. We went through the residential schools and the sexual and physical and emotional and every other kind of abuse that went on. One of my hopes is that the Aboriginal Healing Foundation will start to open up some of those wounds in our people, which will help us heal and become healthier communities. But I'm still waiting on that because there's an enormous amount of homophobia in our communities, which is learned. Internalized racism, internalized homophobia amongst our two-spirited young people, enormous rates of suicide that we know part of it has to do with sexual orientation. We can't prove it because, of course, you can't talk to people after they've committed suicide. One of the reasons I talk about the legal issues not being as pressing for us that are discussed in some of these papers is because of the enormous poverty amongst Aboriginal peoples throughout Canada. The other thing is, the HIV/AIDS Legal Network did a number of papers, and we talked about the fact that Aboriginal communities and issues were not even addressed in them. So they contracted Stephen Matchiation to do 3 papers to work with some of us in Aboriginal communities around HIV and AIDS issues, and he did 3 papers. He did one on discrimination, one on interjurisdictional issues, and another on HIV testing and confidentiality. They're available through the network if you want them. I won't go into any detail. I'll give you a summary of what I think they say. In terms of discrimination against Aboriginal peoples, not only in terms of HIV and AIDS, but in terms of sexual orientation, it appears that Aboriginal Two-Spirited people have human rights, but they are largely unenforceable in Canada. In terms of interjurisdictional issues, it took 500 years to create the mess between the federal, provincial jurisdictions, status Indians, non-status Indians, treaty Indians, non-treaty Indians, the Métis and Inuit. The creation of Nunavut now is going to create some other kinds of issues. So in terms of interjurisdictional issues, we probably need another 500 years to unravel that mess. So HIV testing and confidentiality, there's very, very limited access to HIV testing for most Aboriginal communities. The distances are too far. You go for your test, you spend an enormous amount of money getting there, and then you have to go back for the results. Well, if you're on the medical services branch plane, you have to document what you're going for. So there goes your confidentiality. Other things is some of the remote communities have just nursing stations where the community health representative who's doing the testing and giving you results might be your cousin or your aunt. So we have some real issues around the size of the populations and confidentiality and how you ensure that, and very grave concerns with rapid testing and what kind of consequences that's going to have if it becomes available just, you know, in Aboriginal communities generally. Around legal issues, because the human rights system and the court system are based on an adversarial system, it is very foreign and alien to our people. They do not complain about injustice. They do not complain about discrimination. They don't complain about these issues. They do not use the court system as individuals to pursue their rights. They do not use the human rights commissions across the country or federally to pursue their rights. You'll find that probably in every report I think the federal commissioner has discussed is they have a very, very low percentage of Aboriginal peoples coming forward to talk about discrimination. In terms of things like pensions, we have a high unemployment rate. Two-spirited young people, because of homophobia and AIDS phobia, if you're a two-spirited man in our communities, they believe you have AIDS because they bought the grid stuff and the gay urban disease stuff, which the media seem to leave in our communities and never update. And also, as I talked about, some of the other issues. But our young people, our young men, they will leave their communities because of being rejected by families or being forced off. And they'll come into the cities. They have no life skills, no education, no experience at anything. They usually become involved in the sex trade, injection drug use, and which all of these are high-risk activities for HIV. Of the known Aboriginal AIDS cases, 60% are two-spirited men, young men, a huge number of them under the age of 30. And injection drug use is part of it. Enormous amount of people, enormous amount of women are contracting HIV through injection drug use. HIV is a huge threat to two-spirited community, particularly young men. In Toronto, where I work, I would say about 90% of the people that I see that are two-spirited men under the age of 30 are HIV positive. What does that say for our future? I mean, it's an enormous amount, and that has to do with a lot of things. It has to do with enormous homophobia in the mainstream in our own communities, where there are very few role models, very few people like me who will stand up and say they're two-spirited and challenge you know, our elders and other people and leaders who say we never existed. We have elders who say we never existed, even though their own creation stories from their own culture says that they were created by two people of the same sex, and that, of course, through Christianity, et cetera, has been changed to, you know, two members of the opposite sex. So it's wonder how our cultures translate into other things. If you're interested in some of the issues around two-spirited people, there's a wonderful book called The Spirit and the Flesh by Walter L. Williams. I think it's University of Chicago Press, but I can get that to you if you like. Anyway, I have 2 minutes, so I don't think we can sit and congratulate ourselves around some of the progress that we've made through the court systems when you think about the ethnic and racial minorities who are also dealing with gay, lesbian, bisexual, transgender issues, who are also at the lower socioeconomic scale, who do not have, pensions to deal with. They don't have estate issues, like they're marginalized and they're lost in huge urban centers like Toronto. And if I look around the room, I mean, a lot of us have contributed time and money to these issues and making sure they went through the court system well. But I think we can't stop there. We have to remember that while we're moving ahead here, there are some other more basic issues that are fundamental to people's lives. Things like housing, things like, education, things like that. Homophobia is a big killer in our country, an amazing killer, and we need to demand that the government of Canada and the provincial governments put a lot more money into dealing with homophobia and racism and not putting it on the backs of community groups and the very groups that are discriminated against to do all the work. I think that's a huge issue. And that's, if I can say that, homophobia and racism is the biggest issue affecting two-spirited people in Canada. And I'll stop there.
Thank you, Laverne. Marguerite?
I'm going to try and take you across Europe, I guess, in a very short space of time. One of the things I'd like to emphasize is, very strongly, is that, in my opinion, Canadian jurisprudence and Canadian approaches to the whole issue of human rights are really preeminent, and everyone in Canada should be proud of what has been achieved here. It really, if you look at the situation and you take Europe as a perfect example of going across the countries, it really is outstanding how far ahead Canada is. And I say that because I'm going to put a sort of caveat to that, which is beware the lure of the registered partnership stuff. Do not be taken in by what's happened in Scandinavia and other places. Don't settle for sort of second best. Separate but equal is not equal. So what I want to do is really, you've got the chart in your folder, and I want to just deal with what I think is a pattern, because I think it is important to recognize patterns in law. And really what this chart does, and it's there because I hope that everybody will sort of find it a useful tool, and you can update it yourself, because as you'll notice, I haven't been able to put in every country at every stage. But basically what we see, starting really on the left of the chart, is really the beginning point for any part of the struggle, which is putting our community in fear of the criminal law. Now everyone's congratulating themselves that I suppose that doesn't happen anymore. I'm sure that the RSCMP have homophobic attitudes which come into play in the way that they conduct themselves, and certainly jumping right to the end of the chart and looking at the UK, the UK is still extremely backward so far as the criminal law is concerned. Firstly, we have a criminal law in the UK which says that it's basically sex in private between two men is okay. You put in a third man to that room and you're a criminal. And recently there have been recent prosecution, the Bolton 7 case, which may have got coverage over here, I would think so. The judge in that responded quite well, because he decided that he wouldn't put in any of the hard sanctions and basically conditionally discharge them. But that was really as a result of a big campaign, that they didn't get sent to prison. We still have an unequal age of consent. If you look through the chart, and again, I can't go through every country in the time, you will see there are an enormous number of countries that still have unequal ages of consent. What that means is there are still criminal sanctions, particularly for gay men, though a number of those countries, in fact, include women in that unequal age of consent. What that means is wherever you see that unequal age of consent, it means that if somebody is gay or lesbian, they will face criminal prosecution if they have sex, whereas if they were heterosexual and having sex, they don't face prosecution. So the starting point is that if we look at Europe just before the year 2000, there are still an enormous number of countries which have criminal sanctions against our sexuality. The next area that I look at is whether there are special provisions, things to try and help. The only one I've managed to find was one in Austria, but Austria doesn't come out too well on some other things, so don't look at that as any great shining light. Then what we look at is the next part of the pattern, really, is moving into whether or not there are any constitutional protections. And this is where I think Canada's charter way outshines, though it's not quite as good as South Africa's constitution, puts it right up front, nor the new Swiss one, which apparently puts it right up front. But so far as constitutional reform, what is interesting is if you go through this chart, you'll find practically nowhere in Europe, except I think for Switzerland now, in a very recent amendment, and 2 places in Germany actually have sexual orientation protection in their constitution. Why is that important? I'll explain why it's important, because if we go to Denmark, which is always held up as a great liberal, wonderful, wasn't that nice, first same-sex, partnership legislation and so on, what do we find? 1997, in comes an act specifically aimed at the lesbian community to cut down their access to artificial insemination. And suddenly in a country which, since 1961, has always passed legislation which could be interpreted in positive terms so far as the lesbian and gay community, suddenly in 1997, no constitutional protection, in comes an act which is anti-lesbian, but there's nothing that you can go to. So it is the decision in M&H and the decisions here under Section 15 are extremely important. And what is worrying, and I listened with care to what was said by the earlier speaker, what is worrying is if there is going to be an attack, and the community here should be aware of that, if the Supreme Court is going to be attacked for giving constitutional protection, effectively that means, and if we look at Europe we can see the pattern, it means that homophobic legislation can then come in. So be aware of that, because that is obviously going to be an important part of the campaign here. Again, if we look at Europe and you look through the columns of the various countries, the next area that I looked at was actual specific sexual orientation anti-discrimination legislation. There is very little. It is quite surprising. You would anticipate that there would be a lot more. What has happened in Europe, and it's been one of the debates there, is a lot of people have tried to get in gay and lesbian issues under the rubric of sex. Now that has been successful for transsexuals and transgender cases in Europe, and there was a recent extremely good decision for a transsexual in the UK under the European Convention, under the European Court of Justice, not the European Court of Human Rights. They're 2 distinct bodies. But so far as getting gay and lesbian rights in under the European Convention under sex, the decision of Grant against Southwest Trains, which I'm sure anyone here who's following this kind of stuff in Europe, it's a lesbian couple in Europe. She wanted the benefit of free travel for her partner, which heterosexuals got. European Court, no way. That was refused. Simple benefit of free travel on the railways. Part of the reason for that is that the European Court of Human Rights in Strasbourg is effectively the Council of Europe. It's not the same thing as the European Union, which is the 15 countries. It's a much wider body, and it has encouraged particularly since the breakup of the Soviet Union, an awful lot of Eastern Bloc countries whose record on human rights generally, let alone on lesbian and gay issues, is poor. And it is a court which operates on consensus of the lowest common denominator. And certainly if you're talking in terms of lesbian and gay rights in Europe, that means very little indeed. So in terms of anti-discrimination legislation, effectively what one should look to is certainly not the European Convention on Human Rights. One should look to the national organizations to try and get more anti-discrimination legislation nationally. You can see, not surprisingly, the countries that have it on the chart are Denmark, Sweden, Ireland, Netherlands, and Norway, and France. Very, very few. The next area that I looked at on this chart, which I think is of interest, is, again, it's those very basic incidents of equality or things that are important in existence. Asylum law. There is a very, very mixed picture across Europe on asylum law for people who are fleeing persecution because they are gay or lesbian. And again, the reason why constitutional protections are so important and why you should look to protecting your decisions of the Supreme Court here. If you take Sweden, again, nice liberal country, etc., etc. What did they recently did in an asylum case? They took an Iranian man. They did eventually grant him asylum, so that seems all very nice. But what they said was, okay, he was fleeing persecution in Iran. They haven't actually executed anyone there since 1997. That wasn't accurate, actually. I think they executed someone in 1998. But they took that position. There'd been no executions. And they weren't executing people because they were gay, but because they were committing gay sexual acts. Nice one, eh? So, therefore, he wasn't being persecuted because he was gay. So I repeat myself on the constitutional protection. Why, if you have a good Supreme Court, why, and a good constitution, why that is extremely important. That leaves me 2 minutes to cover immigration, partnership, children, and adoption. Okay, so speaking very fast. I've covered as much as I can in the chart, but I think what is important is the registered partnership. What I see that is very, very much as a red herring. And certainly in the Netherlands, which recently introduced this legislation, the lesbian and gay community there are very strongly pressuring the government in the Netherlands to create same-sex marriage. And it looks as if that may well be a possibility. I would hope it would. I would hope it would, not only because of the impact it will have on the rest of Europe, though the Netherlands, partly because of its policy on drugs, is always seen as a little bit bizarre, but also because hopefully it would give support to any case that was taken here if there was support from another jurisdiction for that. I certainly am of the view, and although some of the registered partnership pieces of legislation in Europe are better than others, I certainly take the view that they are very much second tier. And what we have to look at is what do they attack and why? Basically, the majority of them, it's children. Why? And it can only tie into the stereotypes of what gays and lesbians are about. We're either unsafe or we're unfit. We can't adopt, we can't have AI. That's what underlies that whole thing. It comes from a totally homophobic place. So I would urge you to resist the lure. Sometimes it's tempting to take steps along the road to reform and say, oh, well, we'll settle for this now because that'll make it easier. I think in this context in Canada, it might make it more difficult. I'd look to your courts. Certainly in the UK, and I'll close with this, the surprising thing in the UK, which has, as you can see, I suppose because it's a jurisdiction I know most, I've written the most, but one of the most extraordinary things is if we look to the family judges the judges in the family court in the UK, they are coming out with some quite radical judgments. Martha mentioned one of them, Ward, Mr. Justice Ward, in her paper. They are coming out with some quite radical judgments, and very often, it's a thing I never thought I'd heard myself say as a lawyer, that we might look to judges to be a little more radical than legislators on lesbian and gay issues. Too many legislators seem to be terrified, despite opinion polls which tell them the opposite, that in some way, if they're for lesbian and gay rights, they will never get elected again. Okay, thank you.
Thank you, Marguerite. Mark? And I see you've stolen my 2-minute note, so you have your own time clock there.
As a law professor, I'm programmed to speak in 55-minute segments. You are very brave to give up an afternoon to come and listen to this. I would urge the society in the future to make the programs more expansive, perhaps a title such as What Judges and Lawyers Should Know About Gay Rights. Something like that does more than just speak to ourselves. But it's very important that we do speak to ourselves and that we know what's happening. Because the last 5 years of jurisprudence in Canada has put this country 25 years ahead of the United States. Most recently with M&H, the decision that Justice Epstein described this morning as the decision that just made sense. It does make sense. We should be able to sue each other. That's what this... You should be able to sue each other because then the government doesn't have to pay for our benefits. Although the courts have been tremendously supportive, the Parliament is just bizarre. And the most recent measure, which is not binding, reminds me of the Defense of Marriage Act, which was binding in the United States and which President Clinton signed, although it did not actually defend his marriage after he signed it. Given the advances in gay rights, most of which are entirely unknown in the United States, the question arises now as to whether we are persons. This, of course, comes from the Persons case, where the Privy Council reversed a unanimous decision of the Canadian Supreme Court that had held that women were not persons under the British North America Act, and that women could not be summoned to the Senate. In reversing the Supreme Court, the Privy Council said that the burden of proof should not be on the women or on their male supporters, but on those who would say that they are not persons. So the question for us is, are we persons? The answer to this, I think, depends on at least 4 factors. First, who you ask. Second, where you ask them. Third, when you ask them. And fourth, who else is listening to the answers. First, who are we? Now, there's a lot of factors that go into this. Are we gay, lesbian, bisexual, transgendered? What is our gender? Are we male, female, transgendered, or intersexual? Most people don't know intersexuals. And gay and lesbian people have as much difficulty dealing with transgender persons and intersexuals as straight people have dealing with us. And I think that until we realize that the issues of discrimination are the same in sexual orientation and gender identity, that we all have a lot of learning to do on this. Race is another factor that comes in, because I remember, for example, one black lesbian who was attending a teaching conference, and there was a time for breakout period, and she could choose either to go to the African American breakout room or the women's breakout room or the gay and lesbian breakout room, and she's just, why can't you just have 3 different times for me to deal with these different aspects of my life? Race is a controlling factor that also depends on who we are. Age, as Marguerite was mentioning on the younger end of it, involves different ages of consent, and that not only affects prosecutions, which she mentioned, but the ability to provide services and information to young gay and lesbian persons who need that. Religion is another aspect, whether we are persons accepted by our faith. The Roman Catholic Church says it's okay to be gay as long as you don't practice. I think it's okay to be Catholic as long as you don't practice. So we sort of some agreement on that as well. Reverend Fred Phelps, who is from my country, not the only American coming to Canada this month, is a preacher whose religion lets him sit in his own pew. If you want him not to come, you just have to not provide police protection for him. if you just send him a fax saying, we cannot guarantee your safety, he won't come, won't show up. If he does show up, one of the best responses you can have is just to have big sheets, like sheets from a bed, put them on posts, and stand in front of his signs. Political affiliation is another factor that determines who we are. In my country, Democrats and Republicans have many things to say about gay issues. If gay Democrats are meeting, the candidates will actively seek out their endorsement. If a Republican candidate sees the log cabin group, they will run out of the room to avoid having to get their endorsement or to take any money from them. Economic status is another thing that factors into the decision of whether we are persons, because if you have money, you can avoid discrimination. Our HIV status is another factor, and other personal factors, including whether we're in a relationship, whether we have only recently come out, and other things like that. I've described these more in the paper that's available now for you to insert in behind tab 5. In addition to the question of who you ask, whether we are persons depends on when you ask them. If you ask during a moment of celebration, like during a gay pride parade, or on the day that M versus H is announced, or on the day that Romer versus Evans was announced in the United States, the case that struck down the Colorado referendum that discriminated against gay and lesbian persons, the answer will be yes on those days. It will be yes on days of smaller personal victories, such as when a judge told a young high school student that he could take his boyfriend to the prom, or more recently in my state of Illinois, where the Illinois Appellate Court, from the bench, reversed a trial court decision that had denied adoption to two lesbian couples. And not only did they reverse, they apologized publicly to the women and to the citizens of Illinois. The following day, she was removed from the bench by the presiding judge, and I think that's the first time that this woman's a judge's homophobia has led directly to their being removed from the bench. The answer will be no in other contexts when we ask whether we are persons. If we ask after a fag bashing, for example, especially if the police have refused to take down the details that would have established the hate motivation for the crime, or if the prosecutors plea bargain the crime away to some lesser charge, the answers will be no. The murders of Matthew Shepard in Wyoming and Billy Jack Gaither in Alabama are just two sad reminders of how serious this problem is for us. Where we ask this question is another important factor. If I ask a gay soldier in Canada whether he's a person, the answer is yes. If I ask a gay soldier in the United States, he can neither ask nor tell. Some jurisdictions still have their sodomy laws, others not. Some have non-discrimination laws, others not. Some companies have non-discrimination policies. Other companies, such as Cracker Barrel, continue to insist that sexual orientation discrimination is necessary to promote the family image of their business. Some city and county governments now offer domestic partnership benefits to their government employees. Some companies do so as well. They do this even to the exclusion of heterosexuals, and one federal court decision has now held that it's not unlawful to discriminate against unmarried heterosexuals. If you want to have a domestic partnership benefit program, you can limit it to gay and lesbian persons and not violate the U.S. Constitution. Some jurisdictions include gays and lesbians in their hate crime statutes, others not. Some allow gay and lesbians to adopt, only one doesn't, Florida, and that's under challenge now. And as Martha McCarthy mentioned this morning, in New South Wales, there's new legislation to give gay and lesbian couples the same rights of property, inheritance, alimony, and other medical decision-making. The fourth aspect that I identified about whether we are persons depends on who else is listening to the answer. If I were to be candid, I probably say different things to different audiences. I recall the movie Rashomon, where there's a rape scene, and the story is told 3 different times, and each different time, one's from the husband, one's from the rapist, one's from the woman. Maybe there's even a 4th in there. It's been a while since I've seen the movie. Each one of those creates a compelling version of truth. Now, and sort of left to live with this ambiguity as well. If I am arguing about the need for stronger hate crime laws and enforcement, can I do so without disclosing the dirty little secret of gay and lesbian domestic violence? Or can I argue for stronger hate crime laws without also remembering the discrimination and attacks on transgendered persons, simply because I'm so concerned with my own problems in my own community? If there's nothing wrong with being gay, can I still argue that gays have a right to privacy? Can I argue that that outing should be a tort or not? If I ask the media to treat me with respect, must I also ask them to give the same respect to the drag queens, drag kings, leather daddies, circuit boys, bears, radical fairies, and dykes on bikes that you'll see this weekend? So are we persons yet? The Persons case held that women were eligible to be called to the Canadian Senate. I think gays are also eligible to be called to the Canadian Senate, and more of them should do so. Sven Robinson is so much in the public's eyes that there are even stories written about him now that do not mention that he is gay. But we have made incredible and unquestioned progress. Our bars were once mafia-run and police-raided. We now have vibrant and profitable bars and other businesses. We also have openly gay police officers. But we still do have raids on bars. Most recently, I understand the Bijou was raided this weekend. I was not one of the Americans who was arrested there. Where gay Canadians were among the psychopathic personalities that were excluded by the United States, my country now, as others, offer political asylum to those who suffer persecution based on sexual orientation discrimination. Where federal employment was once limited to heterosexuals, there's now a presidential executive order that protects gay and lesbian workers in the United States, and openly gay employees of the U.S. State Department are now demanding equal benefits for their same-sex partners. Lawyers were once disbarred for being gay. We are now not only lawyers, but leaders of local and national bar associations, judges, and even one of us is a justice on the High Court of Australia. Local bar associations, including most recently the DC Bar, conduct surveys that measure the impact of discrimination on our communities. Where judges once ruled against us, even the dissent in M versus H says discrimination on the basis of sexual orientation is abhorrent and corrosive of our values. That's from the dissent. At least one judge in my state was taken off of the bench because of her homophobia. Where teachers were once fired for being gay, and where gay student groups were denied meeting spaces and funding, we now have openly gay faculty members and directors of gay and lesbian studies programs. We don't have it all, but we still want it all. We're not satisfied with domestic partnership benefits, and we shouldn't be, because we should have the equal access to rights that all citizens of all countries should have. So, as was held in the Persons case, the burden of proving that we are not persons should fall on those who would deny our personhood. I think that for us, though, we don't have the same burden of proof. We have a dual burden of proof. As John said, there's still a lot of work ahead. We have a lot to do. And I think that in the first instance, we must come out to ourselves, our families, our employers, our communities, and even our nations. We must come out privately and come out publicly. This is our burden of proving who we are. Once we meet this, once we do this act of coming out, we prove that we are persons. The second part of the Persons case then kicks in, that anyone who would deny us that personhood has the burden of proving that we are not persons. Thank you for your time.
Thank you, Mark. Now, we are pressed for time, but I do want to...
I was 3 minutes over.
Yes, you took my note away from me. I thought we do have some time for questions and start any roundtable discussions, and so I would invite anybody who may have a question to speak now. Douglas.
Laverne, you and I have talked about this in the past, and the history that you talked about is remarkably absent from any of the major decisions that we've talked about today, Egan, emanation, so on. It's as if the history starts with the arrival of John Cartier with respect to Canadian lesbian, gay, bisexual, transgender communities. How do you think we can go about rectifying that gap in our historical knowledge, particularly given the fact that you've identified a sort of cultural gulf between the sort of white lesbian gay activist community that's off in courts doing things about pensions and so on, and may not relate to the First Nations view of non-adversarial and having all these other socioeconomic issues. How do you think we can bridge that gap in order to make a better society for everyone?
Well, that's a tough question because probably when, given the enormous amount of homophobia in our communities, if you start raising that when you talk about history, they'll probably get very upset with you because there is still that homophobia. But I think that what I try and do all the time when I'm talking about it is raise this. I mean, this is documented. You have, letters from missionaries and explorers talking about how disgusting it was that these men were running around in, dresses and sleeping with each other and stuff like that. So it's documented, and that our communities didn't have a problem with it. And there are, all sorts of documentation and things like that. These things should be raised when the issue does come up. Although there then will be the accusation that we're revising history to suit our own, to suit modern times and political correctness. It's very difficult, but that's what I do all the time, is just raise it and say there is proof.
Andrew.
Appreciated the comments, because one of the themes that runs through everyone's presentation are the advantages and disadvantages of compromise. Speaking could address the situation in Europe, talking about going down the wrong alley. I read something recently, it was just a letter to one of the main Toronto newspapers, which raised the issue of gay men wanting to donate blood. And my understanding, and I could be wrong, is that is still prohibited if I write down that sex with a man, then I don't get to donate blood. And I guess my understanding of that issue is that has been seen as a battle that is maybe not worthy to fight, and perhaps Doug, you sound like you'd probably know a great deal about this issue, but it's one of those issues that on the face of it is a stereotype and certainly demeans a very valuable contribution that anyone would want to make. So I'd be interested in anyone's comments on that issue.
There is no right to donate blood. And having said that, I agree with your assessment of it. And I remember participating in the marches in New York with the Haitian community, who was also excluded from the blood donation lists put out by the CDC. Within a week of a massive march on going across the bridge, hundreds, thousands of people there, the restriction was removed and to allow Haitians to donate blood again. Wouldn't be a per se thing, but it's just something that we have to choose our battles, and this just hasn't been one of them, because you can also not donate blood if you've had a cold and other things like that.
John?
Yeah, and there's two elements to your question. One is around the role of compromise. The other is on the specific issue of blood donation. I don't see this one as a question of compromise so much. I think that's another interesting question around when governments or courts offer you something less than what you're looking for, in what circumstances is it okay to take what you can get at the time and leave other battles for a future day or whatever. But on the specific question around blood donation, to me it's more a question that the way the questions are currently framed just don't address the risk factors in a coherent way. It does reinforce stereotypes that being gay creates risk rather than sexual behavior. It creates false senses of security for heterosexuals who think, okay, I'm heterosexual, therefore I don't fall into that risk group, independent of sexual behavior. And I don't think anybody would question that the blood authorities have the right to ask questions which are rationally related to the security of the blood supply. And since there are non-stereotypical ways of asking the questions that would give the right answers, it's difficult for me to understand why they would choose to focus on questions around what is your sexual orientation. So I think it's a legitimate concern. I think it's a concern that's better addressed through attempts to educate those asking the questions than through kind of acts of defiance. There was a lot of publicity around a guy who lied on the form and then came out afterwards and said, I deliberately lied in order to make a political statement. And that's, I mean, given the difficulties we've had with the blood supply, that's only going to set things back in terms of trying to educate and inform. And so I think linked with your question is also another question around what are the best tools to challenge different types of exclusion. There are times when I think the courts and the legal system are a good tool. There are times when I think political activism is a good tool. There are times when I think public demonstrations are appropriate, and there are times when I think education and information are the best tools. And I think in this case it's around education and information rather than activism or demonstrations or civil disobedience, if you like.
Any other questions? Well, John, sorry, go ahead.
Yeah, and I must say that AGAL also found it an extremely positive experience to work with a coalition of 13 different equality-seeking communities on the Rosenberg case, including a variety of different racial and ethnic communities, poverty organizations, women's organizations, disability rights organizations. And it made for some interesting conference calls, but also for, I think, a submission that was a lot stronger by virtue of having been informed by that variety of perspectives. And some of the linkages between the struggle for same-sex relationship equality and poverty rights, for example, were important, because there was a temptation to respond to the Egan case by saying, well, Rosenberg isn't that case, and Egan was about public benefits and finances and all that kind of thing, whereas Rosenberg's about a pension plan that you pay into and because it's funded. And the poverty rights groups were very clear in saying, we don't want precedents that's going to say that in some circumstances it's okay to deny social benefits because if you're seeking access to government funds. And there were lots of examples of how the broader range of perspectives, I think, strengthened that submission. So it's a good challenge, because I thought the story that was told about the women at the conference having to choose which of the various breakout groups to go to resonates, because it's an issue we see time and time again, that we have lesbians and gays working for rights here, race groups, poverty groups, all working in their own corners, and people who belong to more than one of those communities often feel caught in the middle and torn between their where they put their energies and focus. And it was a good story about how it's doesn't necessarily have to be that way, and the groups can come together to work on common projects.
Yes.
Yeah, please.
I wouldn't mind playing with that, because from the sort of UK point of view, you have a very, very similar pattern. A Labour government that was elected with a huge majority, aimed at being, sort of radical, which had as part of its agenda abolition of Clause 28, which is the anti-gay and lesbian local government clause. It's taken 2 years for the minister to come out and say, we are going to repeal it. We'll have the next Labour government, no doubt, in the UK before it does it. For some reason, politicians, and I mean it is basically homophobia, I have no doubt of it, and fear of the electorate, which judges don't seem to have they do in the States, obviously, but they don't in Canada and the UK. But it is that fear of the electorate, and even when opinion polls tell them, and they do in the UK as well, that the general public are not put off of the idea of lesbians and gays as parents, for example, and they agree with adoption and so on and so forth. Nevertheless, the politicians are extremely, and it's partly, that's one aspect of it. I think it's also tied into that family values kind of politics, which is so, sort of prevalent in the West at the moment, sort of the traditional family, which is really a sort of shorthand way of saying, sort of the patriarchal white family. That's what we want. We want really the white men back in charge of the family. It's that kind of interplay between the things which I think the politicians both support and are wary of. So I don't know, but it's not just in Canada that you get that sort of, even when they've had a huge majority in the UK, when they had it in their manifesto, they still haven't done anything. It's very odd.
Yeah, I agree entirely with everything you've said there. By and large, the politicians are scared and they're weak on this one. Marriage is what they see as the big one, and we've only made any progress in the political scene by virtue of them all reassuring each other that don't worry, this won't lead to same-sex marriage. And the extent to which that fear runs deep can be seen in the fact that there were a number of NDP MPs who voted in support of the Reform Party motion. There are a number of Bloc Québécois MPs who voted in support of it. The Reform Party itself, that didn't bother me and wasn't a surprise. We, they're against everything. The government was a disappointment to me because there were many Liberal MPs who were uncomfortable with the Reform Party motion, didn't necessarily want to support it, but the government didn't just come out and say we support it. They had a whipped vote, and they pressured those who wanted to oppose it to support the Reform Party. And I was disappointed also in the NDP and Bloc MPs, and it's clear that there are those who are okay with relationships generally, but when it comes to marriage, in terms of the strategic implications, the government tried to convince me that they were in fact being really supportive in opposing same-sex marriage because, and I have to think about how this goes, it's because they are wanting to move forward on the relationship issue generally. They know that their caucus is uncomfortable with the issue of same-sex relationships and is scared that it will lead to same-sex marriage. And therefore, by the government coming out and clearly opposing same-sex marriage now, they have given themselves the freedom to move ahead with omnibus legislation on same-sex relationships, while reassuring their colleagues that it's okay, this won't lead to marriage because we've made a clear statement on that one. And given that we wouldn't have won marriage anyway for some years to come, it will have little impact by the time the marriage issue is on the table, but will enable the caucus to feel more comfortable supporting the marriage bill. And I think probably there is something in that, although I ultimately was not convinced that this was a terrible move or a great move in support by the government.
I think it was maybe an environmental vote to protect Canadian trees because they obviously think there's a shortage of marriage licenses and they didn't want to print up more of them.
I hope it's a quick question. We're running from time, Karen, sorry.
I learned in law school, my professor said we celebrate little victories too much. We kind of give credence to the process, and as progressive people, we face many more defeats than victories. And with the utmost respect and admiration for Martha, I think M&H is nice, really nice. But I have not forgotten what the Corporate Appeal setting group agreed. I haven't forgotten Egan. I haven't forgotten Lawson.
Or Andrews.
I have forgotten, does anybody here think the Supreme Court of Canada's had an epiphany? I mean, this is nice. But I'm not out of the woods yet, and they have said sorry to me.
That's right. Thank you, Karen. Please join me in thanking our panel for their I have now the very distinct pleasure to introduce our closing plenary speaker. Kathy Lahey is our closing speaker and has held the position of Professor of Law and Queen's National Scholar at Queen's University Faculty of Law since 1987 and is cross-appointed to Women's Studies there. Before moving to Queen's, she was a tenured full professor at the University of Windsor Faculty of Law and a visiting scholar at Harvard Law School International Tax Program, senior lecturer, Monash University Faculty of Law, and lecturer, Osgoode Hall Law School. Professor Lahey's main areas of teaching are research and publication include taxation, property, charter, and human rights law, women in law, and law and sexuality. She is the author of the forthcoming book, Are We Persons Yet? Law and Sexuality in Canada, and we thank her for giving us a title for our program today. I also can tell you that we will be having some order forms at the reception afterwards tonight. The book will be available July 14th. A table outside, thank you. Douglas has the order form. Now that's Professor Lahey's CV. I think I want to speak a few minutes about someone I have known for many years who arrived at Kingston the same time I arrived as a young, naive first-year law student during orientation week, which was the biggest misnomer I'd ever heard at Queen's University. I had been warned not to go to Queen's because it was the feminist university law school, and of course that's where I went. And during orientation week, I was handed a petition to
essentially have the lesbian tax professor fired. And I'm not sure I ever even told you this story. I, of course, was immediately horrified that I had obviously come to the wrong university, and also gratified to think, oh my God, I'm not the only one here. And who is this person teaching tax? These were the dark ages, before we actually then moved forward at Queen's. And by the time I left law school, Professor Lahey had been at the very core of a massive transformation in legal education. By the time I left, there was QLAG, it was called then, Queen's Law, Lesbians and Gays. There was feminist jurisprudence courses, feminist advocacy courses being taught, and the dialogue that was going on at Queen's. We call it the heady days, those of us who survived it. But it had a major and lifelong transformation for me, pardon me, personally, and I think for anybody who went through the Queen's system since then has benefited from it. So it's with great pleasure that I invite Kathy to come and talk to us and thank her for her amazing contributions to our community and to legal education.
Thank you, Terry. I had no idea that any of that went on there. I was just so busy sort of doing my thing, which I guess, if you believe the rumors, included inciting students to take over other classrooms and demand equal time for feminist and other issues. But it has been an amazing sort of 10 or so years in Canada. I was recently doing a little sort of bar chart to see how many cases have been brought in Canada relating to sexuality, like since forever. And it would be like one case in 1974 lost. Then a few years later, another case would be brought and it was lost. And really, the bar chart was practically flat until you hit, I think it was the year you were saying, or somebody was saying, it was 1992. And then all of a sudden, it's just, it's zoomed right up there. There's been a massive amount of litigation. The success rate is now well over 50%. And the kinds of cases that are being brought, I think, are mattering more and more, which is why I was sort of incited to begin working on the topic, are we persons yet? Because I guess I've been looking for a measuring stick, sort of how do we tell? We can look at what's going on in other countries, we can talk to each other and say, how's it going for you? It's going a little bit better for me, sort of, trade stories and look for other indications of how we're doing. But this is what I came up with as sort of a measuring stick for the assessment of how sexual minorities, a shorthand term for talking about lesbians, gays, transgender people, transsexuals, bisexuals, intersex people, and any other sexual nonconformists who want to join, are doing. I know that there's a problem with the concept of legal personality or personhood because it involves sort of buying into the dominant discourse. But let's not kid ourselves. Especially as lawyers, we really can't escape the dominant discourse. It has been dominant for so very long. The concept of legal personality is 2,000 years old. It's the core concept in any Euro-influenced legal system. Nothing that I've seen anywhere has come close to beginning to change the way that we think about the functioning of law or the way in which adult human beings sort of set up normative orders. The concept of legal personality, I decided, is essentially the grammatical glue that holds clusters of rights and responsibilities together. It is the way in which law talks about which people are going to matter, which people will have lives that have significance, not only on a day-to-day sort of de facto basis. Yes, we can breathe. Yes, some of us can walk freely down the street. But which human beings have lives that can consist of acts with legal significance? The difference between de facto existence and juridical or legal existence. So the concept of legal personality, to me, although it's a very narrow, sort of classical, traditionalist approach to talking about the nature of law and legal functioning, nonetheless, I think offers us a not bad way to get that kind of critical standpoint from which we can assess how we are doing with this movement that has resulted in the sort of radical transformation of the bar charts. So my position is that the concept of legal personality is essentially sort of totally crucial to the ability to function. And in order to analyze how sexual minorities have been doing, I have really just sort of looked back to Roman civil law, to the original sort of codification of what constitutes legal personality, as a way to sort of set up a checklist of how sexual minorities are doing. What is legal personality as classically or traditionally conceived? It's the ability to sue or be sued, the ability to act as a witness in a legal proceeding, the right to sit on a jury. It is the ability to be a citizen or a person who has all of the prerogatives of an adult human being in a culture. The ability to vote, the ability to hold public office, the ability to enter into a public forum or enjoy public services. And it is the ability to enjoy the private law rights of entering into a valid contract, owning property, being able to contract marriage, the right to have custody of children. It's a very simple sort of concept, but it is, because it goes to the concept of capacity to act, it is a very powerful sort of way to describe the way people function. The Roman Civil Code had a whole sort of legal structure in which some classes of people were given all of those capacities. Some of them were given none of them. Women, for example, could never have any of those capacities. Children could not have them until they became the father with the power in their particular family. Aliens could not have those capacities. And so you go down the list of people who mattered in that culture. This is a very powerful way for the legal system to allocate political status, or a very powerful way for political systems to maintain hierarchies of privilege and depowerment. So in the paper that is included in your binder, I have sort of listed examples of situations throughout the last 2 millennia in which the incidents of legal personality have been manipulated in order to maintain particular hierarchies of privilege, and not coincidentally to maintain the depowered status of unpopular groups. I find it particularly interesting that the first and most clear-cut example of the use of legal personality, or the denial of legal capacities to a particular group of people on a widespread basis, can be found in the Visigothic Code, which was enacted or adopted in about the year 450 in the Common Era. Something called the Arian heresy was used as the political basis for putting the power of the state and the power of the civil code behind the program of the government, which was to put as much pressure as possible on Jewish people to become Christian. And you read through the Visigothic Code, and every possible legal capacity was denied to Jewish people in order to give them no alternative but to convert to Christianity. Not only were they not permitted to practice their own religion, but they were not permitted to seek protection from violence, and even judges who attempted to prevent the imposition of violence on Jewish people could be subject to the death penalty themselves. So it was a complete denial of legal capacity, that is, the right to matter jurisprudentially. In this same code, you find what I have been able to identify as one of the first sodomy provisions, which had much the same function in terms of policing sexuality. And as you go through laws that have been enacted since that time, you find the same kind of sort of extreme abuses of concepts of legal personality. I've listed off examples English law is notorious for its denial of legal capacity to women as well as to Jewish persons, minors, incompetent persons, and so on. North American law imported the concept lock, stock, and barrel when it used it as the basis for setting up the slave codes of the southern United States. And even after the Emancipation Proclamation was adopted in the United States after the Civil War came to an end, the black codes also provided for the wholesale erasure of the legal capacity of former slaves. In Canada today, we still have laws known as the Indian Act, which completely erase the legal capacity of people classified as status Indians under the Indian Act, because all of the powers to act legally are given to the minister. And people who are living under the jurisdiction of the Indian Act have the ability to de facto act, but their acts have no legal significance until they receive the approval of the relevant minister. The list of examples could go on, but the main point that I'm trying to make here is that the concept of legal capacity as it is classically understood not only explains to us why and how law can oppress unpopular groups, but it also points to what I think is the most effective direction for dissension and revolution, if we could think in terms like that. Where the capacity to act is denied by law, it then becomes necessary for the law to restore legal capacity. And that's where you find a tremendous difference between what judges do and what legislatures do. If you look over the history of what we could call the human rights movement or the movement for constitutional personhood, we find that constitutional documents play a very, very important role. But it is ultimately judges that give those constitutional documents meaning. It is judges who can read constitutional guarantees that are absolutely stellar in the way they are framed as having no effect, and it is judges who can take a simple word like the word person and read legal significance into the lives of whole groups of people. So if I had to choose, I suppose I would choose looking to the judiciary ultimately as the place to try to find some sort of long-term protection for the legal capacities of people like sexual minorities who have historically experienced so many different forms of jurisdiction, or sorry, so many forms of discrimination that is justified by their lack of legal capacity. Now, Judge Epstein said something earlier today which I found very striking. She said that she was not sure that lesbians and gays should necessarily seek access to all the same rights as heterosexuals. And I think that's correct. But I'd like to distinguish between legal capacity and rights. If you don't have legal capacity, then it doesn't matter whether you can get your hands on some right or another. Without capacity, there's no right. Think in terms of legislation that deals with, for example, incompetent persons. If a person is found to not have capacity to act significantly in law, then they will not, therefore, have any rights. So taking a quick look then, using this sort of jurisprudential measuring stick to evaluate what has happened to sexual minorities in Canada, I'd like to just make the following points. First of all, I'd like to just look for a couple of minutes at how the denial of legal personality or legal capacity has been accomplished in Canadian law. And I would say that this is not unique to Canadian law, but this particular overview, I think, fairly reflects what has happened in Canadian law. There have been two judicially promoted presumptions that have lain at the heart of the legal incapacity of sexual minorities. The first is the presumption, and this is a variant of the Arian heresy, if you like, in that it's a presumption that morality should drive state doctrine. The presumption that there's something inherently immoral about same-sex sexual conduct, the immorality presumption, which continues today to the extent that same-sex sexual activity is still criminalized, can still lead to criminal liability if it is not carried out in private. So the sort of privateness of acceptable same-sex sexual conduct reflects the continuing vitality of this sort of immorality presumption. The other presumption is something I call the heterosexual presumption, and I think probably we have someone in this room here who's borne the brunt of the heterosexual presumption in her own life. Biological findings, so to speak, made by courts have been linked together with a sort of vague sense that legal capacity has to follow biological capacity. And if same-sex couples do not have the biological capacity to reproduce with each other, then they must not have the legal capacity to form legally recognized relationships. For example, the Karen Andrews case. So the presumption that a person may include a woman, but that a couple cannot include same-sex partners is reinforced by looking to these so-called biological findings to sort of insert this heterosexual presumption into law. And if you read the earlier cases that have been decided in Canada, this heterosexual presumption that sort of goes back to this sort of biological assertion really sort of runs through all of the cases. Many of them cases to do with relationships, but not all of them cases to do with relationships. Now, another factor that has resulted historically in the erasure or impairment of the legal capacity of same-sex partners and of sexual minorities in Canada has been something that I would call the opposite sex movement. In 1974, as the result of recommendations contained in the Royal Commission on the Status of Women, the Veterans Act was amended to include the term opposite sex when describing the cohabitants who could qualify as war brides for pension benefits under the Veterans Act. The Veterans Act had previously had a common law spouse category, which was expressed in terms of sex-neutral terms. Coincidentally, in 1974, we also had the specter in Boulder, Colorado, of people rolling into county clerk's offices and saying, "We'd like a marriage license, please." And the county clerk saying, "Oh, there's nothing in this statute that says no homosexuals," because it simply used the words persons. So in 1974, you had the specter of people getting married in Boulder, Colorado with perfectly valid marriage licenses. And you also had the North and Matheson case, which was being decided in Canada. So the federal parliament decided, better put the words opposite sex into the definition of cohabitants in the Veterans Act. And shortly thereafter, omnibus legislation that was adopted by the federal government began to insert those two little words into every statute that it took up for anything. And if you just amuse yourself someday, go do a QL search on opposite sex. It's like this little sort of legislative virus that has spread across the country, to the extent that by the time the problem with the human rights codes, which is that they protected against discrimination on the basis of sex, but not on the basis of sexual orientation, was amended to include sexual orientation, you had the Ontario legislature also sliding in there with Ian Scott making this speech, right? The words opposite sex in the definition of spouse in the Human Rights Code. And right there in Hansard, you have Ian Scott saying, there's nothing in this legislation that's going to interfere with the traditional definition of marriage. So For a long time in Canada, we've already had a more muted version of the Defense of Marriage type of act going on, and that's the opposite sex movement. So you add all of these things up together, and you got a position described on pages 3 and 4 of the notes in your binder, showing that in pre-charter law, there was a vast number of situations in which sexual minorities, predominantly lesbians and gays, but by no means exclusively lesbians and gays, because you had lots of transgender and transsexual people who were litigating right along with lesbians and gays, being told that they did not have a wide variety of rights. And these rights all boiled down to the denial of different forms of legal capacity. Now, that was the past. Things look like they've changed. How did it happen? We can identify a couple of factors that have resulted in changes. The Charter of Rights absolutely has to be the key thing that has resulted in the transformation of the jurisprudential scene in Canada. It resulted, first of all, in the insertion of sexual orientation into the Ontario Human Rights Statute. At least the government of which Ian Scott was a member was able to convince people that the Charter required them to put the word sexual orientation into the Human Rights Code in Ontario in 1986. But secondly, and probably more importantly, although I'm by no means saying that that was an insignificant development, the Andrews test of discrimination, the Oakes criteria for application of Section 1 of the Charter, the demonstrable justification clause, did eventually displace both the morality presumption and the heterosexual presumption that had riddled pre-charter law, and replaced those presumptions, which themselves were based on prejudice and stereotype, with objective criteria that led quite quickly, in cases like the Vasey case, to a number of breakthroughs. One was a court just simply saying, you know, hey, we look at this family visiting policy that Corrections Canada had produced, and we don't see how it excludes same-sex partners. So you suddenly had judges sort of reading sexuality-neutral legislation as if it included same-sex partners, to the extent that I would almost say that the Vasey case could be seen as the person's case of queer law in Canada. Secondly, in the Vasey case, you had the court going through the Andrews criteria and saying, you know, well, this is probably all true, you know, these problems with capacity, the problems with biology, the problems with morality, but they said, you know, look, it says here in Andrews, you know, is this a disadvantaged group? Is this discrimination? Does this legislation burden? So the court just sort of went down the checklist and they got to the bottom of it and they said, you know, oh, this violates the Charter. And from then on, you had sort of a snowball effect where court after court quoted Vasey, then the next case, the nodal case in BC was quoted, and so on, until you got to what I consider to be probably one of the most important cases in Canada, the Hagen-Birch case, in which the Ontario Court of Appeal agreed that the Charter was powerful enough to put sexual orientation into human rights codes that didn't already have it. And that, of course, was the federal statute. That then accelerated into the decision in the Leshner case, which pushed into the area of private rights, contractual rights, recognition of relationships, and so on, and the cases began to move in a direction that was simply not possible before the Charter was enacted. So that brings us to the question of today, are we persons yet? A number of people have offered answers that sort of fall sort of generally in the area of, well, I'll call it sort of, or, you know, getting there. With the caveat that I'm using this in the classical jurisprudential sense. I'm not gonna go in that direction. I'm gonna say no, we're not persons yet. We are absolutely not persons yet. It may be that it's starting to look like it. There's the M&H case, absolutely the most wonderful decision by the Supreme Court of Canada I've ever read. There's Bill 32 in Quebec, There's the British Columbia Family Relations Act. There's the British Columbia Law Institute recommendations for registered domestic partnership legislation, and an increasing number of successful cases at the administrative, grievance, judicial level, etc. But the problem is, and this is the problem that is illustrated by the appendix at the end of the notes in your binder, the problem is that if you break the classical incidence of legal personality down into the two fundamental categories of individual or personal rights, such as the Vriend case, in which there was the right to go to a human rights commission or the right to employment, versus relational rights, then you see that we're actually doing pretty well on the sort of individual or personal rights. But when it comes to the relational rights and all of the factors that they include, there is still a tremendous gap in the law. Because legal personality, full legal capacity, consists of both personal rights and relational rights. Now, the core problem, and we've touched on this in a number of different ways already, so it's pretty obvious, with the recognition of relational rights is the continuing denial of the right to marry, because it has a cascading effect on a number of other rights that can be allocated under the current legal system. This cascading effect sort of flows partly into the whole marital property regime system that you find in each jurisdiction. The cascading effect also goes and touches all of the rules that relate to the determination of the parent-child status or the status of a child with same-sex parents. And it also goes into all of the areas of statutory and private law, everything from tax credits, tax deductions, to insurance, pension rights, and so on. Now, it's a little bit confusing, I admit, because the expansion of cohabitation rights, the expansion of the definition of cohabitant, the attack on the opposite sex qualification for recognition of cohabitation has begun to blur the effect of excluding same-sex partners from the institution of marriage. But take a close look at what's happening with the cohabitation rules. There is no jurisdiction in Canada, indeed there is no jurisdiction in the world, where same-sex partners have every single right and responsibility of recognized cohabitants. There are hundreds of such provisions in each jurisdiction, and although some of the omnibus statutes, such as the Quebec statute, touch a lot of those, they don't begin to touch all of them. They're going very much in an incremental or piecemeal fashion. But even in jurisdictions where cohabitation is a so-called free state, such as Quebec, cohabitants have no legal status under the Quebec Civil Code, which regulates the incidence of marriage. Yes, there are Quebec statutes, such as insurance statutes, that recognize cohabitation, but not the Quebec Civil Code, which has to do with marital regimes. Even in the free state in which cohabitants live in Quebec, they have genuine freedom. They have the freedom to marry. But the cohabitation that is being extended to same-sex partners is not that free a state, because there is no right to elect to marry. And if you read marriage legislation, you find that sexuality is still just as much an incapacity as being a minor, being too mentally incapacitated or incompetent to contract marriage, or it is as incapacitating as already being married to someone else. So in terms of legal capacity, I would say that same-sex couples and sexual minorities generally are not full legal persons. Now, in these notes, I have described this movement toward registered domestic partnerships as a threat, as something that may well actually put the current sort of trend toward success, may slow it down, may create problems. And that is because If you take a look at registered domestic partnerships, take a close look at them, nowhere in the world does a registered domestic partnership set up anything but either second-class or third-class relationship recognition. And nowhere, I think I will say, as a hypothesis at least, has the second or third class status conferred by registered domestic partnerships been at the request of lesbian or gay communities. The example that people usually look to first is the domestic partnership model that you find in Denmark. And I'll just run through what some of the problems with that model are, because that is sort of the analytic starting point for those who are interested in this legislative model. First of all, in Denmark, couples who want to enter into a registered domestic partnership have to register at civil offices. They are prohibited from having a religious ceremony. The reason for this is because of the immorality that is associated with same-sex conduct in Denmark. They are therefore denied access to clerical mediation, which is considered to be one of the big forms of conflict resolution in the matrimonial area. Lesbian couples do not have the right to artificial insemination. Same-sex couples may not jointly adopt children. A same-sex registered partner is not considered to be a single person for purposes of adoption, so that is not an option either. If, despite all of these rules, a same-sex couple does come to have a child or two, and it has happened, and if they break up, they are not legally permitted to have joint custody of any child that may be considered to be their child. And just to make things perfectly clear, there is no possible recognition of parental status between the non-legal parent of such a child. In addition, both people involved in a same-sex registered partnership have to be citizens and residents, a limitation on marriage rights that would be really unheard of in other jurisdictions. There are some variations on this model in Europe, but nowhere are all of these disabilities or incapacities eliminated. And I would go so far as to say that this new system that has been proposed in France, which is called the PACS, actually sets up a system that rigidly segregates same-sex registered partnerships and marriages. There is no cohabitation recognized for heterosexual couples. So in France, you simply have formal marriage for heterosexuals and the PACS, or a registered union for same-sex couples, and opposite-sex couples cannot qualify for that. British Columbia, in the form of the Law Institute, has recently proposed a registered domestic partnership model, which, although it does not prohibit access to artificial insemination, that right has been secured as the result of a tribunal decision, Benson and Korn in BC. Nonetheless, this is a variation on the registered partnership model, which I don't know. I guess I have a hard time describing it seriously. It's the any two adults can register model of domestic partnerships. Two roommates, two friends, two siblings, a parent and a child, tennis partners can register their partnership and can thereby acquire all of the rights and responsibilities of marriage, including a forced share of the deceased partner's estate, a forced share of the partnership home, a share of the net partnership estate, rights to support, the right to renounce a will, and so on, can be claimed as the result of registration under the British Columbia model. It is also possible to register secretly for all of those same-sex partners who have been out there so busily agitating for political change that they forgot to tell their parents or something. None of this, however, has changed the step-parent classification to which same-sex parents are assigned. And all of the rights of cohabitation are still not available as the result of this legislation. It's a modification of the French PACS model in the sense that in BC you have three categories. You have heterosexual marriage, you have the anybody any two adult human beings with legal capacity can register as domestic partners. And then you also have the category of sort of conjugal marriage-like cohabitation. And same-sex partners can choose from cohabitation and registered partnerships. Heterosexuals can choose from all three forms, and of course, tennis partners can choose the registered partnership model. I would go on, but the basic point that I think is very clear when you take a look at registered domestic partnership legislation as it has evolved around the globe is that essentially all of these statutes appear to offer relationship recognition, and they do. They do solve some immediate short-term problems with less paperwork than was previously available, but they all strengthen the marriage bar. And from the point of view of the Canadian context, I consider them to actually be dangerous because a jurisdiction that has adopted a registered partnership model can look, when defending itself against a suit for denial of marriage rights to its registered domestic partnership model, and say, as did Judge Sapinka in the Egan and Nesbitt case, you know, this is an incremental reform in the process of gradual recognition of da-da-da-da, and it is demonstrably justifiable in free and democratic societies, such as Denmark, Sweden, etc. So I think that they all form a serious threat, and I think that they help emphasize that when you're filling in sort of the little chart at the end of these notes, help emphasize the fact that the right to marry column continues to be completely blank. Now, I'm not advocating marriage for anybody. I think, however, that it's just fine to have the right to marry and not exercise that right. I think that the great discrimination here, the great denial of capacity, is the denial of the right to choose whether or not to marry. And in order to just emphasize why I think that this is a very important aspect of the sort of long-term civil rights struggle that sexual minorities have been involved in, I'd like to just point out some of the parallels, again, in the United States that emerged after the Emancipation Proclamation was declared, to help sort of just give a comparison to what seems to be happening with lesbians and gays today. Before the Emancipation Proclamation, slave codes prohibited marriage absolutely, and slaves did not have right to custody to their children, and needless to say, nor to access to their children. After the war, statutes were passed called Civil Rights Act, declaring that former slaves were persons, declaring that they were emancipated, and spelling out all of the civil rights that they then had. Usually those lists included maybe 2 or 3 things. And then the list followed of the things that they still did not have, such as the right to own real property or the right to move around freely in their own communities. But one of the rights that they were given was the right to marry. It was a very odd form of marriage. They had the right to register at the local city clerk's office, and they were applied to marriage in the form of anti-miscegenation laws. Something like 35 states in the United States eventually enacted laws that made it a criminal offense to marry across what was considered to be the racial bar, and religious justifications of the most profound kind were offered for this anti-miscegenation legislation. 101 years after the Emancipation Proclamation was put into effect, the Supreme Court of the United States did declare that those anti-miscegenation laws did violate the Equal Protection Clause of the 14th Amendment to the United States Constitution, but it took quite a long time before social attitudes sort of began to change in accord with those kinds of decisions. Now, I think it's very easy to say that registered domestic partnerships or even omnibus legislation that gives partial recognition by assimilating same-sex partners to the status of cohabitant is an improvement. But the other problem with it is that it is totally segregating. It creates complete segregation in the law. It is separate and it is not equal. I think that there's absolutely no basis for claiming that it is equal. Now, where does this leave us? Well, I think that to get very quickly to my last point, where this leaves us is in a very difficult position. British Columbia will be looking at its legislation very quickly, I think. M&H has sort of lit a fire that is going to spur that on. The Ontario government has until November 20th to do something. And what? Will it look like Bill 167, which left same-sex partners out of all of the marriage rules? Or will it look like a registered domestic partnership? It's going to look like one of the two. There are no other models out there. The Law Commission of Canada has funded a major conference to be held at Queen's University on the advantages of domestic registered partnerships for Canada. I didn't organize it. And it does have a session on other alternatives to registered domestic partnerships. But I think that that's a pretty good signal for people who are looking for signals that registered domestic partnership legislation is looking pretty attractive to parliamentarians. Now, there is a little bit of light at the end of the tunnel. The chairs of this CBO committee have decided that they are going to schedule a large working session in September, which will basically be set up as a consultative meeting in which people who are concerned about the legal capacities of sexual minorities in Ontario can give their opinions on what forms of legislative recognition they would like to see. So I urge you to tell everyone about this meeting and come to it being prepared to get involved, because I think that it's probably going to be the best chance to try to head off the insertion of legislation into Ontario statutes that will be very difficult to fight when we're down to the Section 1 Oakes test. That's all I have to say.